Good morning, sir. Are you James Wheeler?
Yes, ma'am.
And let me get myself up to speed here. Mr. Wheeler is currently on probation in cause number 23 DCCR 1800 for the offense of fraudulent use or possession of identifying information. There was an administrative hearing filed, sent over back in May of 2024, and a motion to revoke that probation filed. Allegations of committing the new offense of public intoxication, testing positive for methamphetamines, testing positive for amphetamines, not adhering to a curfew, being behind in his fees a little bit, and then failing to report for intake in Hardin County. It looks like a recommendation of SafeP after a substance abuse assessment was done on April 16th of 2024 that returned to probation May 7th to discuss the recommendation. Denied using drugs, however, allegedly tested positive on that day. And before the matter could be addressed, left the building. Advised his officer that he was going to make arrangements to go to his own detox program in Austin. Probation said, can't pick what you want to do. And so we're here now with the motion to revoke. Mr. Kimler has filed a motion asking that I set a bond. Mr. Wheeler is on a deferred probation, typically entitled to a bond unless there's certain findings. Actually, this is a straight probation. It's a 2/5. Okay, I've received some information that Mr. Kimler sent over. Do you have an opportunity to review that? Mr. Kimler, you may proceed. Did you want to call your client?
Well, I think I'll let him decide that, Your Honor. Just speaking on his behalf, if he wants to address the court, I'll let him do that. But this is a non-violent offense. My first observation, of course, many times when I move forward the court, I know that the state argues the safety of the community is paramount in consideration of the bond. I'm not trying to downplay the seriousness of fraudulent use of identifying information offense, but I would just observe to start with that it's not a crime of violence. Mr. Wheeler's struggled on probation. We want to get him back on track, and as part of that, it would be admission to bond where he could report, continue to work, hopefully not have a positive drug screen so that he can come back in front of the court for a disposition of the case. The court's going to revoke him or keep him on probation. They'll be in the best possible position to argue that he should be continued on probation.
Speak up, please.
So that he would be in the best possible position to ask the court to continue him on probation if he would have the opportunity to be in bond, show that he can demonstrate compliance.
Okay, Mr. Nichols.
If he's, whatever bond the court deems appropriate is fine by me, Judge. He just needs to monitor. He needs a drug patch. He needs to be reporting. And seems to have a problem doing those things when he was on probation before. I'll note for the court, on a separate probation, he was sent to safety in 2020.
I saw that.
And obviously it has not worked. So I agree it's not technically a violent offense, but his drug use is concerning, Your Honor.
Do you want to address the court?
If I may.
Hold on. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I have had a history of drug use. When August 4th, my firstborn child was born, and when I heard her cry, I was done. I never touched it again. I put myself in the Franklin house as lay manner, and I went there for 30 days doing aftercare. CPS was with us up to taking 9 drug tests. Negative and a hair follicle. I'm just ready to provide for my family. And that's why I turned myself in so I can go back and get this out the way and fixed to where I could go to work because I couldn't get a job because of the warrant. And I'm really excited to be a father. It's really, I'm trying to put this on the right track so I can get moving.
So one of the things I did get one of those letters is from the caseworker that had some positive things to say. So, I'll deal with the bond. I'll set one, but what's the plan? I mean, do we not want to go ahead and go through the motion while we're
Okay.
here, and that way we can then set it for,
You can
instead of
please.
coming
We
back?
don't lose you.
So will he waive the formal reading of the motion?
So,
So we're going to go through this motion, get pleas of true or not true to those allegations, reset it for sentencing, and then we'll talk about the bond and conditions of that in just a minute, okay? So I have in cause number 23, DCCR 1800, motion to revoke your community supervision. Shows that you were placed on probation March 19th of 2024 for fraudulent use or possession of identifying information. That was a 2-year term in the state jail prison that was probated for 5 years. Is that right?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the offense of public intoxication March 26th of 2024. And is that true or not true?
Yes.
Count 2 alleges that you provided a urine sample April 16th of 2024 and May 7th of 2024 that tested positive for methamphetamines. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 16th and May 7th that tested positive for amphetamines. Is that true or not true? I'm sorry.
True.
speak up.
Count 4 alleges that you were at a location other than your residence at approximately 11:15 p.m., March 26th of 2024, and is that true or not true?
Yes.
True.
True.
Count 5 alleges that you are, as of May 7th, 2024, you were $240 behind in your fees. Is that true or not true?
True.
And then count 6 alleges that you failed to report to the Hardin County Probation Department for your intake on April 9th of 2024. And is that true or not true?
It is true, but hard
True,
to
true with an explanation.
Yeah, we'll get an explanation later. All right, so did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And so I'll get a little more information about what's going on. Now, with regard to a bond in your case, I'm going to set a bond at $5,000. But you're going to have a condition of that bond, if you make it, that you have to wear a drug patch at all times. You've got to have a drug patch put on within 24 hours of your release from custody. If it tests positive, then you're back in jail and all bets are off.
Thank you so much.
If there's more, if you have a drug patch that's not testable, I'm going to assume it's positive. So you need to make sure, wear it properly, do whatever you need to keep it on, and go every 2 weeks like you're supposed to get it tested. I think, I don't know exactly what I'll do. I mean, obviously it sounds like some treatment would be required. Wouldn't hurt to go ahead and get started on some outpatient maybe. But we can wait, or you can go ahead, probation's here, and whatever you think is appropriate at this point while we're waiting on sentencing, give those orders and I'll sign off on them.
Yes, ma'am, I was gonna give him a new assessment done to see exactly what it is that he needs and get him started.
Perfect. Okay, because it sounds like since the last assessment, there's at least been some treatment, so maybe that'll, recommendation will change. Okay, all right, you can go back with the bailiff.
Here we have a lifelong criminal who has been charged with credit card and debit card fraud. He has violated every possible probational period that he has received for past crimes, but he received another softball sentence. Sit back and let's see how this case plays itself out. Make sure you subscribe and like this video.
Good morning, are you Christopher Bishop? And will your client waive the formal reading of the motions and the new indictment?
Yes, Your Honor.
Mr. Bishop, in cause number 24 DCCR 1659, you're charged with the state jail felony offense of credit or debit card abuse from May 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $300 fine and pay restitution in the amount of $45.95. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bishop is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. So is there any reason, I see probation's here to get a pre-sentence report. It looks like the other cases are all to be continued. Is that correct?
Yes, ma'am.
Any reason to get a pre-sentence report?
No, ma'am.
And for probation, you're in agreement with all of this as well? Okay, so I'm going to, yes, ma'am.
I believe we abandoning count 1.
Hold on, I'm not there. Let me get done with this new case yet, and then, yeah. I'm going to, again, find that you entered that plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of credit or debit card abuse, sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. You're ordered to pay a $300 fine. You're ordered to pay that restitution in the amount of $45.95 and follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and, you could be, your probation revoked, and you could go to state jail prison for that 2 years that you've already agreed to. Do you understand?
Yes, ma'am.
Now, okay. In cause numbers 18-29813, 17-26803, 17-26802, and 17-26800. In all of those cases, I have first amended motions to revoke your unadjudicated probations. Shows that you were placed on probation in 3 of those cases for burglary of a habitation on December 4th of 2017. And those were 8-year deferred probations. Is that correct?
Yes, ma'am.
And then in the 18-29813 case, you were placed on probation November 26th of 2018 for burglary of a building, a state jail felony. Shows that was an 8-year deferred, so that must have been enhanced.
I believe it was a burglary of habitation.
Okay, let's make sure.
Because the paperwork on the tablet has habitation that we did.
Nope, that's not it.
PSI shows it was burglary of habitation.
Let me look back at the actual plea documents and stuff like that real quick. So that, he was on probation, committed that one. and
This
then
one
got-
was done a month before the others, but it wasn't indicted until afterwards.
Okay, thank you. So do you want to make an oral motion to amend that 18-29813?
Yes, it should be burglary of habitation.
Any objection
No
to that?
objection.
And then after, instead of state jail felony, second degree felony, correct?
Yes.
Any objection to that,
No
Ms. Holmes?
objection.
Okay, so in that final case, you were also placed on 8-year deferred probation for the second degree felony offense of burglary of a habitation. Is that correct?
Yes, ma'am.
Okay. Now, each of these allege that you violated your probation.
That's abandoning count 1 in each case.
All right.
This is dismissed.
Thank you, sir. All right. The state's elected to abandon count 1 in each of those cases. Count 2 in each of the cases alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 3 in each case alleges that you tested positive February 8th, March 18th, June 6th, June 11th, July 1st, and July 11th for tetrahydrocannabinol. And is that true or not true?
That's true.
Count 4 in each case alleges that you failed to submit to a substance abuse assessment and follow the treatment plan. Is that true or not true?
That's true.
Count Count 5 in clause number, I hate it when they're not the same. Count 5 in clause numbers 17-26803 and 17-26802. In each of those cases, count 5 alleges that you're behind in your court assessed fees. And is that true or not true?
That's true.
And then count 6 in those 2 cases, count 5 in the other 2 cases alleges that you committed the new offense of credit or debit card abuse on May 9th of 2024. And is that true or not true?
That's true.
Did you enter your pleas of true to all of the counts except 1, which was abandoned, in all 4 of these cases? And did you plead true to those counts because they're actually true?
Yes, ma'am.
Give me just a second. Get organized here. In each of these cases, I have here on the computer documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you also go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And you understand also if I follow these agreements, you'll be waiving or giving up any right to appeal.
Yes, ma'am.
And it looks like the agreements is that you would remain on probation. I would continue your probation. I would extend it in each case for 2 years. I would order as a condition of your probation that you enter and successfully complete the substance abuse track of ISF, and that when you get out, you would go through the JCDI program as your aftercare. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Let me get caught up here. In each of your cases, I'm going to find that you entered your pleas of true freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probation, but I'm not going to do that. You're getting a great opportunity today. I'm going to continue you on each of those probations. In each case, I'm extending your probation for 2 years. I'm ordering as a condition of your probation in each case that you enter and successfully complete the substance abuse track of the ISF program, that you successfully complete the JCDI program and follow all of the rules and conditions of probation. I'm also going to order, well, I'll get to that in a second. In these 4 cases, you're still on that deferred probation, which means you don't have these felony convictions. Take advantage of this opportunity, get back out, get on the right track, and you'll never have these convictions. At the end, the cases will be dismissed if you're successful. But as a reminder, if you violate again, you'll be right back in here. It's very unlikely that you will get the same opportunity again. And in these cases, if you violate, you could get up to 20 years in prison. Do you understand? All right. Now, I want to go back real quick. In cause number 24 DCCR 1659, which is that new case, I'm also going to order as a condition of that probation that you enter and successfully complete the substance abuse track of ISF. I want it ordered in all of the cases. It just keeps it a little cleaner as well. And also the same JCDI program when you get out. Do you understand? In just a second, I'm going to hand you, did I print one yet? 803 is what I printed. 800. Okay. Nope. Here, it's coming. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, so you've waived your right to appeal. Give me just a second. Taking it a very long time to go from here to there. Okay, and then I also need to go over, when I hand you all of those, I'm also going to hand you an admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment in that new case, that credit debit card abuse case, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read this written admonishment that I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. Take advantage of this opportunity. All right, ma'am, are you Devin Atkins? And Ms. Atkins is on probation for the 3rd-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Down there, call, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devin Atkins?
Yes,
Do you see Ms. Atkins in the courtroom here today?
yes.
Can you point to her identifier?
Right here in the blue jumpsuit.
Your amended record reflect Ms. Cole has identified your probationer Devin Atkins.
Record will so reflect.
And Ms.
Printing.
Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes,
And each one of those in detail is gone over with them so that they understand everything that they're required to do. correct?
yes,
Was Ms. Atkins so advised?
yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes,
And were in fact a majority of those things intended to help her?
yes,
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
yes,
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order?
yes,
Did you address that with her and inform her, it is important to report, if you have something coming up, you need to let me know?
yes,
And did she do that?
no,
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
yes,
And to report those to you?
yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes,
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading this one. No wonder everyone's looking at me.
I was about to say- I know, I was about to,
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is at all times?
yes,
And if she does not do that, is it impossible for you to locate her?
that is
And
correct.
did she in fact immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I address anything?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes,
during
sir.
your supervision? Okay.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Ms. Evelyn Thibodeau, I believe that is her grandmother, correct?
Yes, respectfully.
hold on, ma'am.
At some point in time in November of 2024, was Ms. Atkins violating the condition the court had imposed that she not to have contact with Ms. Thibodeau for Ms. Thibodeau's safety?
Yes.
Thank you, Judge.
Any questions about that? About
No.
the count, that's count 8 with the contact? Okay. Then, at this time, based on the testimony, I am going to find count 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
No, from the defense, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, the been able to take advantage of any services that spinal-tap inmate Jamar may have, or any programs that probation deemed appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. You know, she did understand that she had the Safe P opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation and be able to complete this
I
assessment.
mean, it's hard when
Hold on.
Jamar's not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. What, did she go to regular Safe P or special?
not.
Hold on.
Special needs.
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be, what?
Evaluation where?
At Spinaltop.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you
That's
have.
what it's called, PASS program. I'm not a psychopath. That's what I'm
That's not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your, I'm sorry, Ms. Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just this runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as,
I have one more thing to say.
okay?
She is not giving me the information needed to follow up with those type of things.
Okay, well, I don't
She doesn't
believe
have
you.
them.
I don't believe you.
You don't
Ms.
believe-
Cole would never say, go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health. And the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things
I
that,
was gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty.
Drug test.
Don't talk
I would
over.
like to look over.
I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling, like she thought, like I could not get up there.
I'm going to hand you the trial court certification that shows this
I would
was,
like to speak to a detective.
this was not an agreement, and so you waived your right to
said
appeal.
had
I need you to
hospital
sign
records.
that
I
with
gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you,
doctor's appointment and everything. That's what I'm
I've got
telling you.
5 more years that I could add on to that.
Oh, man.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
against,
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
Talking
don't.
to the wrong person. I'm Devin Atkins. I don't have a gun.
I'm required
No,
to
I'm
read that
telling
to
you, I don't
everyone.
know what you're talking about. I don't have a gun.
Good, then you don't have to worry about that. Go back with the bailiff. Good morning, ma'am.
Good morning.
You are Melody, is it Meshy?
Mesh.
Mesh.
Yes, ma'am.
And Ms. Mesh was previously here, entered a plea of guilty to the 3rd-degree felony offense of forgery, as well as the 3rd-degree felony offense of unlawful possession of a firearm by felon. I've received the pre-sentence report as well as a supplement that was provided with regard to some more specifics on those Louisiana cases. Did everyone receive that?
I have not received the supplement, Your Honor.
Y'all didn't?
It's fine with me.
Well, they should have. Was it emailed to them? The supplemental thing would have been emailed to them or something, right? There's a supplemental report. No, it was sent after the PSI.
Don't know, but usually they attach it to their.
Nope. Okay, we need to just make sure they get those. It shows that it just kind of clears up some of those records unavailable ones on the PSI from November 9th of 2011, which isn't really on there, so I'm not real sure where this came from. There was, well, maybe it's the, oh, that's when she pled no contest to the OWI, operating while intoxicated. 6 months in jail, mostly suspended, 24 months probation. Probation was revoked June 20th of 2013, ordered to serve the 6-month sentence. And then there was a OWI third offense that she pled to October 24th of 2012. Got probation, it was revoked, requiring her to serve the full 3-year term back in 2013. Couple other things that have to do with driving, but those are the main ones that are, looks like, weren't available on this. So, other than that, has everyone, any other additions or corrections to that report? Mr. Rojas?
Not anything.
Ms. Delfino?
Judge, I know Mr. Brown's PSIs is that always are very extensive and thorough. I have a little hesitation with the defendant's comments in her section about taking responsibility. I don't really believe she was just kind of innocent bystander as she claims to be. I think the nature of the offenses in my read of them do justify probation that the court agrees, but the reason for the straight offer was obviously criminal history and accident time alone. Or whatever the court thinks is appropriate.
And I have spoken with Ms. Mesh about those comments, Your Honor. She's, as far as the counterfeit goes, she's aware that the person she was with had that kind of history. She's aware that there were those documents inside the car. She should have known.
It wasn't just documents, the printer was in the car.
The equipment, yes, ma'am, the equipment that was in the car.
I mean, you can't act like you don't know that's going on if the printer and the counterfeit bills are in the car and you're passing them. Goodness gracious. Like I need to start today over. I mean, so Ms. Mesh, I don't know how long you've been sending it in here. Obviously, it's extremely disturbing to me. Number one, your criminal history. Number two, the fact that you're not taking responsibility for this at all. Even if it wasn't your idea, you're not taking any responsibility for it. And it makes no sense when you're in the car with the printer, with the bills, you go into stores, you're trying to pass the bills in the stores, and you're saying, well, I was just in the car and he put the gun in my purse and he did all that stuff and I didn't really know about it.
Yeah, that's not exactly right.
That's not right. So tell me what's right. Because you pled guilty under oath the other day.
I knew the gun was there, and I knew he did counterfeit. But I didn't think all the money he gave me was counterfeit. I really didn't.
Did you think some of it was counterfeit?
I'm sure, yes, ma'am.
Okay.
Yeah.
Well, just take the responsibility. You know what I mean? It's not going to make it better for you to try to diminish it at this point. It's done. You pled guilty to it.
Yes.
It just makes it worse. If you stand in front of me and try to say, well, I didn't really, I mean, yes, you knew some of it, if not all of it, was counterfeit.
Yes, ma'am.
He's printing it in the car. Jeez. How long has she been in jail? Okay. Where will you live if I let you out on probation?
I live in Lebanon.
I mean, I'm guessing you must have lived in Louisiana most of your life, is that correct?
Yes, ma'am.
And then you moved over here?
Yes. I've been in other states, but I stayed in Lubbock, Texas for about 3 years. And my grandson now is a heavy equipment operator and he's coming to work down here. My daughter does cancer treatments in Houston.
I saw that. So you live with your niece and grandniece and now?
Yes, ma'am. Which she just had surgery too.
And all those things, I feel for everybody else in your family, but I mean, you're the one who got yourself here,
Yes.
you know? Okay. I'm going to find, Ms. Mesh, that you previously entered your plea of guilty freely and voluntarily. I'm going to find in cause number 24, DCCR 2378, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of forgery. I'm going to sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 25, DCCR 0134, find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do everything you're supposed to on these probations, then for all practical purposes, your case here in court is over. And you'll be able to serve your 10-year term while you're out on probation. The other side to that, though, is if you violate any condition of probation, and I want you to understand that means any condition. This is the second time I've said this today, and I feel like I might say it more. You will be on zero tolerance. Your criminal history doesn't really, on paper, you don't look like you should be given this opportunity. I trust Ms. Malfino, her look at the case. I'm going to go follow the agreement, but I want you to understand that if you don't take advantage of this opportunity and do everything you're supposed to, you're going to be right back in here and you're going to be facing those 2 10-year sentences that you've already agreed to. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you already know this, but I'm required to.
And that's the lesson from this explosive courtroom moment. When the stakes involve years of your life, every decision matters, including what you say and when you say it. Judge Raquel West made it clear that the courtroom isn't a place for endless interruptions or arguments. What do you think? Was the judge right to draw such a hard line, or did the defendant deserve more patience? Drop your thoughts in the comments, and don't forget to like and subscribe for more intense courtroom moments and legal breakdowns.